Freedom of speech has been under attack in this country, and Colorado has been a big part of it. First, Jack Phillips of Masterpiece Cake Shop has spent 10 years trying to defend his right not to be compelled to create custom cakes with a message which violates his beliefs. So when Lorie Smith wanted to expand her business into developing custom wedding websites, she was concerned that Colorado would do to her what it was doing to Jack Phillips. Her request for an injunction went all the way to the Supreme Court. We'll look at that case next, right here in the Constitution Study.
Neighbors and have a few good friends. Every day we're everyday Americans. Oh, every day we're everyday Americans.
Hello there, everyday Americans. Paul Engel here with the Constitution Study, where we read and study the Constitution, teach, rise, and generation be free. I am glad you could join me today. It's an interesting case. I've been waiting for this case to come out because it really deals with freedom of expression, and there's a lot of interesting stuff in this case. Speaking of websites, I have plans for the Constitution Study website that I hope to be releasing soon, but I'll talk a bit more about that at the end of the episode. For now, let's take a look at this 303 creative case. Freedom of speech includes the freedom not to be compelled to speak as well. But what happens when a person's freedom of speech conflicts with a state's law? In the case 303 Creative LLC versus Elenis, the question was asked if the state of Colorado could dictate to Ms. Smith what type of message she had to communicate in her business. Like many states, Colorado has a law forbidding businesses from engaging in discrimination when they sell goods and services to the public. Laws along these lines have done much to secure the civil rights of all Americans. But in this particular case, Colorado does not seek to ensure the sale of goods or services on equal terms. It seeks to use its law to compel an individual to create speech she does not believe. The question we face is whether this course violates the free speech clause of the First Amendment. I don't know how many times I've covered this, but then again, I doubt the justices of the Supreme Court watch these videos. This cannot be a First Amendment case because Congress did not make this law. The First Amendment reads, Congress shall make no law abridging the freedom of speech or the press. Now, since Congress did not make this law, it cannot be a violation of the First Amendment. So what this case truly is a violation of Article 2, Section 10 of the Colorado Constitution, which reads, no law shall be passed impairing the freedom of speech. Every person shall be free to speak, write, or publish whatever he will on any subject, being responsible for all abuse of that liberty. It's also a violation of the 14th Amendment of the Constitution of the United States. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. While the court opinion appears to focus on the First Amendment and freedom of speech, the real issue they are looking at was freedom of the press. Specifically, does the state have the power to compel others to publish content with which they disagree? Through her business, 303 Creative LLC, Lorie Smith offers website and graphic design, marketing advice, and social media management services. Recently, she decided to expand her offerings to include services for couples seeking websites for their weddings. As she envisions it, her website will provide couples with text, graphic arts, and videos to celebrate and convey the details of their unique love story. The websites will discuss how the couple met, explain their backgrounds, families, and future plans, and provide information about their upcoming wedding. All of the text and graphics on these websites will be original, customized, and tailored creations. The website will be expressive in nature, designed to communicate a particular message. Viewers will know, too, that the websites are Mrs. Smith's original artwork, for the name and the company she owns and operates by herself will be displayed on every one. Ms. Smith wants to create and publish web pages without being compelled to use them to communicate a message she does not agree with. Well, at least that was her plan. While Ms. Smith has laid the groundwork for her new venture, she has yet to carry out her plans. She worries that if she does so, Colorado will force her to express views with which she disagrees. Ms. Smith provides her website and graphic services to customers regardless of their race, creed, sex, or sexual orientation. But she has never created expressions that contradict her own views for anyone, whether that means generating works that encourage violence, demean other person, or defy her religious belief by, say, promoting atheism. Ms. Smith does not wish to do otherwise now, but she worries Colorado has different plans. Specifically, she worries that if she enters the wedding website business, the state will force her to convey messages inconsistent with her belief that marriage should be reserved to unions between one man and one woman. Ms. Smith acknowledges that her views about marriage may not be popular in all quarters, but she asserts the First Amendment's free speech clause protects her from being compelled to speak what she does not believe. The Constitution, she insists, protects her right to differ. Now, I'm sure this language came from Ms. Smith's attorney because it uses the same phrases I've seen in other opinions used by lawyers. Since I've already explained why this case cannot be a First Amendment issue, let me explain why it's a free press case, not a free speech one. Both the First Amendment of the United States Constitution and Article Section 10 of the Colorado Constitution protect both freedom of speech and press. Have you ever considered the difference between the two? Webster's 1828 dictionary defines speech as the faculty of uttering articulate words or sounds. Ms. Smith isn't planning to utter articulate words or sounds in her business, but publishing websites, which, according to Noah Webster, is freedom of the press, which is defined as the art or business of printing and publishing. While Ms. Smith, and for that matter the Supreme Court, sees this as a First Amendment freedom of speech case, it's really a Colorado Constitution freedom of press case and a 14th Amendment privileges and immunities case. To clarify her rights, Ms. Smith filed a lawsuit in federal district court. In that suit, she sought an injunction to prevent the state from forcing her to create wedding websites celebrating marriages that defy her beliefs. To secure relief, Ms. Smith first had to establish her standing to sue. That required her to show a credible threat existed that Colorado would, in fact, seek to compel speech from her that she did not wish to produce. Ms. Smith, having seen what happened to Jack Phillips and probably others, initiates a preemptive strike, filing a lawsuit and seeking an injunction against the state of Colorado before they've had a chance to infringe on her rights. However, since she has not been aggrieved yet, she doesn't have an obvious standing for the courts. Generally, courts don't appear to like preemptive lawsuits, deciding to wait until someone actually suffers some harm before accepting them. In order to show that she had standing, Ms. Smith had to show a credible threat that the state of Colorado would compel her to publish websites that she did not want to produce. In her lawsuit, Ms. Smith alleges that if she enters the wedding website business to celebrate marriages she does endorse, she faces a credible threat that Colorado will seek to use CADA, the Colorado Anti-Discrimination Act, to compel her to create websites celebrating marriages she does not endorse. As evidence, Ms. Smith pointed to Colorado's record of past enforcement actions under CADA, including one that worked its way to this court 5 years ago. See Masterpiece Cake Shop. Did Ms. Smith have a credible threat that Colorado would compel her to produce websites celebrating marriages she does not endorse? Absolutely. All the court had to do was look at a previous case it had dealt with. Masterpiece Cake Shop Limited versus Colorado Civil Rights Commission. In that case, the court found that Colorado had violated the free exercise clause, not so much because they compelled speech, but because the Colorado Civil Rights Commission was hostile to Jack Phillips' belief. That consideration was compromised, however, by the Commission's treatment of Phillips' case, which showed elements of clear and impermissible hostility toward the sincere religious beliefs motivating his objection. As the records show, some of the commissioners at the Commission's formal public hearings endorsed the view that religious beliefs cannot legitimately be carried into the public sphere or commercial domain, disparaging Phillips' faith as despicable and characterized it as merely rhetorical, and compared his invocation of his sincerely held religious beliefs in defense of slavery and the Holocaust. No commissioners objected to the comments, nor were they mentioned in the latter state court ruling or disavowed in the briefs filed here. The comments thus cast doubt on the fairness and impartiality of the Commission's adjudication of Mr. Phillips' case. Like all such cases, Ms. Smith's case started in district court, where she lost. The case was appealed to the 10th Circuit, which found that she did have standing, but was not entitled to the injunction she sought. Turning to the merits, however, the 10th Circuit held that Ms. Smith was not entitled to the injunction she sought. The court acknowledged that Ms. Smith's planned wedding websites qualified as pure speech, protected by the First Amendment. As a result, the court reasoned, Colorado had to satisfy strict scrutiny before compelling speech from her that she did not wish to create. Under that standard, the court continued, the state had to show both that forcing Ms. Smith to create speech would serve a compelling government interest and that no less restrictive alternative exists to secure that interest. Ultimately, a divided panel concluded that the state had carried these burdens. As the majority saw it, Colorado has a compelling interest in ensuring equal access to publicly available goods and services, and no option short of coercing speech from Ms. Smith can satisfy that interest because she plans to offer unique services that are, by definition, unavailable anywhere else. The 10th Circuit acknowledged that Ms. Smith's website would be pure speech, or really press. So you would think that it would be protected. Unfortunately, under our current and irrational jurisprudence, we have this theory of strict scrutiny, which the Free Legal Dictionary defines as a standard of judicial review for a challenged policy in which the court presumes the policy to be invalid unless the government can demonstrate a compelling interest to justify the policy. Once a court determines that strict scrutiny must be applied, it is presumed that the law or policy is unconstitutional. The government has the burden of proving that its challenged policy is constitutional. To withstand strict scrutiny, the government must show that its policy is necessary to achieve a compelling state interest. If this is proved, the state must then demonstrate that the legislation is narrowly tailored to achieve the intended result. Now, under this interpretation of judicial review, a court can find an act to be unconstitutional, but allow it anyway because of a compelling government interest. The fact that this is a direct violation of both the Supremacy Clause and the justices' oaths to office doesn't seem to bother them one little bit. This Constitution and the laws of the United States which shall be made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States, shall be the supreme law of the land, and the judges in every state shall be bound thereby, anything in the Constitution or laws of any state to the contrary notwithstanding. Now, as the supreme law of the land, once an act is found unconstitutional, that should be the end of the debate. As has become quite common among today's courts, though, they've placed their preferences and opinions above their oaths to support the Constitution. As these cases illustrate, the First Amendment protects an individual's right to speak his mind regardless of whether the government considers that speech sensible and well-intentioned or deeply misguided and likely to cause anguish or incalculable grief. Equally, the First Amendment protects acts of expressive association. Generally, too, the government may not compel a person to speak its own preferred message. Nor does it matter whether the government seeks to compel a person to speak its message when he would prefer to remain silent or to force an individual to include other ideas with his own speech that he would prefer not to include. All that offends the First Amendment just the same. Now, your freedom to speak and publish is not subject to government regulation. Not only do the constitutions of the several states and the United States prohibit government from restraining your expression, no matter how misguided they may think it to be, they cannot compel you or coerce you into expressing the message they would prefer. Suppressing, even eliminating a message they did not like is exactly what the state of Colorado has done with the CADA. As surely as Ms. Smith seeks to engage in protected free speech, Colorado seeks to compel speech Ms. Smith does not wish to provide. As the 10th Circuit observed, if Ms. Smith offers wedding websites celebrating marriages she endorses, the state intends to force her to create custom websites celebrating other marriages she does not. Colorado seeks to compel this speech in order to excise certain ideas or viewpoints from the public dialogue. Indeed, the 10th Circuit recognized that the coercive elimination of dissenting ideas about marriage constitutes Colorado's very purpose in seeking to apply its law to Ms. Smith. Now, before we look at the majority opinion, let's take a quick look at the dissent from Justice Sotomayor, joined by Justices Kagan and Jackson. 5 years ago, this court recognized the general rule that religious and philosophical objections to gay marriage do not allow business owners and other actors in the economy and in society to deny protected persons equal access to goods and services under a neutral and generally applicable public accommodation law. The court also recognized the serious stigma that would result if purveyors of goods and services who object to gay marriages for moral and religious reasons were allowed to put up signs saying no goods or services will be sold if they will be used for gay marriages. Today, the court, for the first time in its history, grants a business open to the public a constitutional right to refuse to serve members of a protected class. Specifically, the court holds that the First Amendment exempts a website design company from a state law from denying wedding websites to same-sex couples if the company chooses to sell those websites to the public. The court also holds that the company has a right to post a notice that says no wedding websites will be sold if they will be used for gay marriages. Reading this opening to the dissent, I was reminded of a letter written by Dietrich Bonhoeffer that was quoted under the title of Theory of Stupidity. Against stupidity, we are defenseless. Neither protest nor the use of force accomplish anything here. Reasons fall on deaf ears. Facts that contradict one's prejudgment simply need not be believed. A quick look at the facts stipulated by both Ms. Smith and the state of Colorado shows that at no time did Ms. Smith deny services to people based on their sexual preferences. To facilitate the district court's resolution of the merits of her case, Ms. Smith and the state stipulated to a number of facts. Ms. Smith is willing to work with all people regardless of classification, such as race, creed, sexual orientation, and gender. And she will gladly create custom graphics and websites for clients of any sexual orientation. She will not produce content that contradicts biblical truth, regardless of who orders it. Rather, she recognized it was illegal for the state of Colorado to coerce her to express a message with which she disagreed. It appears that, as Mr. Bonhoeffer noted, for the dissenting justices, reasons fall on deaf ears, facts that contradict one's prejudgment simply need not be believed. It's like getting directions to drive from Nashville to Boston, but starting in San Diego. It was such a flawed starting point, it's no wonder these justices came to such a ridiculous and, may I even say, stupid conclusion. While the language he used was quite different, it appears Justice Gorsuch was just as confused by the dissenting opinion. It is difficult to read the dissent and conclude we are looking at the same case. Much of it focuses on the evolution of public accommodation laws and the strides gay Americans have made towards securing equal justice under the law. And no doubt, there is much to applaud here. But none of this answers the question we face today. Can a state force someone who provides her own expressive services to abandon her conscience and speak its preferred message instead? When the dissent finally gets around to that question, more than halfway into its opinion, it reimagines the fact of this case from top to bottom. The dissent claims that Colorado wishes to regulate Ms. Smith's conduct, not her speech. Forget Colorado's stipulation that Ms. Smith's activities are expressive, and the 10th Circuit conclusion that the state seeks to compel pure speech. The dissent chides us for deciding a pre-enforcement challenge, but it ignores the 10th Circuit's finding that Ms. Smith faces a credible threat of sanctions unless she conforms her views to the state's. This dissent suggests over and over again that any burden on speech here is incidental. All despite the 10th Circuit's finding that Colorado intends to force Ms. Smith to convey a message she does not believe, and with the very purpose of eliminating ideas that differ from its own. Now let's take a look at the decision the rest of the justices came to. If she wishes to speak, she must either speak as the state demands or face sanctions for expressing her own beliefs. Sanctions that may include compulsory participation in remedial training, filing periodic compliance reports as officials deem necessary, and paying monetary fines. Under our precedents, that is enough, more than enough, to represent an impermissible abridgment of the First Amendment's right to speak freely. Sadly, but not unexpectedly, Justice Gorsuch places the opinions of the court above the supreme law of the land. Rather than recognizing that the state of Colorado has made a law abridging the rights and privileges of the citizen of their state and applying the protections of the law unequally, he points to the court's prior opinions, their precedent, to grant Ms. Smith the justice she deserves. There is one portion of this opinion where Justice Gorsuch does give some recognition to the supremacy of the Constitution. At the same time, this court has also recognized that no public accommodation law is immune from the demands of the Constitution. In particular, this court has held public accommodation statutes can sweep too broadly when deployed to compel speech. In Hurley, the court commented favorably on Massachusetts' public accommodation law, but made plain it could not be applied to expressive activity to compel speech. Although they got to their decision predictably via a convoluted act of judicial gymnastics, the court did, in a 6-3 decision, come to what I believe is the correct conclusion. In this case, Colorado seeks to force an individual to speak in ways that align with its views but defy her conscience about a matter of major significance. In the past, other states in Barnett, Hurley, and Dale have similarly tested the First Amendment's boundaries by seeking to compel speech they thought vital at the time. But as this court has long held, the opportunity to think for ourselves and to express those thoughts freely is among our most cherished liberties and part of what keeps our republic strong. Of course, abiding in the Constitution's commitment to the freedom of speech means all of us will encounter ideas we consider unattractive, misguided, or even hurtful. But tolerance, not coercion, is the nation's answer. The First Amendment envisions the United States as a rich and complex place where persons are free to think and speak as they wish, not as the government demands. Because Colorado seeks to deny that promise, the judgment is reversed. While I disagree with how the court arrived at its opinion, my concerns are not with the conclusion, but the fact that the placing of precedent above the supreme law of the land could just as easily lead the court to another conclusion. If the Constitution does not mean exactly what it says, it can mean nothing at all. And that, ladies and gentlemen, should concern us all. While there are still concerns, today is a day to celebrate an important victory for freedom of expression, whether by speech or by press. I hope this case will also provide relief not only to Jack Phillips, but to Darnell Stutzman and all of our fellow Americans struggling to exercise their rights without government censorship or compelled speech. So 3 cheers for Lorie Smith, for her courage to stand up, for her willingness to see this case through, and for the beautiful website she can now design without worrying that the state of Colorado will try to compel her to publish a message against her will. The idea that the court came to the right answer by the wrong path is so common among the Constitution study, almost as common as pointing out how this cannot be a First Amendment issue. But the idea of freedom of expression, freedom of speech, freedom of the press, and that they've been protected by the Constitution, both the Constitution of the United States and in this case the Constitution of Colorado. And it's to be fairly sad that even though we got to the right answer, courts can't read the plain language of the Constitution, whether in the affirmation or the dissent. But I'm glad Ms. Smith got the justice she deserves. And speaking of websites, I'm looking at making some changes to the Constitution Study website. Changing some of the features, some of the look, some of the feel. So keep your eye out. Hopefully you'll see a change in that pretty soon. While you're at it, maybe you'll consider the Patriots program. See, personally, I took the John Jay Challenge. I read and studied the Constitution so I would know what my rights are and be prepared to defend and assert them. Maybe you can as well. That's the purpose of the Patriots program. It's not to replace what you're doing. It's to help enhance what you're doing, to make sure it's founded on the actual language of the Constitution and on the ability to defend and assert our rights, our freedoms, and our liberties. You can find out more at the website constitutionstudy.com/patriots. While you're there, check out the other things we offer at the Constitution Study. There'll be changes, as I mentioned, but I'm still offering articles and videos and classes and all sorts of stuff. You know, maybe you want to sign up for one of the mailing lists, get my monthly newsletter or my weekly insider update. Maybe you just want to have my articles and videos emailed to you so they arrive in your inbox when they're published without worrying about finding them or censorship. I also hope you'll comment on this episode and tell me what you think about this case and my analysis of it. Or maybe you have your own question you'd like to ask, or you'd like me to come speak at one of your events. You can do all of that there at the website, constitutionstudy.com. You can even donate to the cause to help make sure that I can keep the lights on and keep these programs coming. Whatever you do, I hope you'll come back here and join me, and maybe even bring a friend or two, the next time we meet at the Constitution Study.
Love the neighbors and have a few good friends.